Hi students, and welcome to Module 5 of International Law and Politics of Outer Space. This week we'll look at one of my favorite subjects, the Moon Agreement and property rights in space. And then I want to say something about Assignment 2 due on Friday. The Moon Treaty doesn't have widespread support, but that doesn't mean it's not law, just that it's weak. All 5 of the space treaties are what they call in force. That is, they have support from enough countries that the UN says they've reached official treaty status. But not all treaties are equally authoritative. The grandfather of all space treaties, the Outer Space Treaty, has 102 ratifications. That doesn't look like a lot since there are 193 states in the UN, but every spacefaring country has ratified it, which makes it pretty commanding. The same with the Rescue Agreement with 92 and the Liability Convention with 89 ratifications. In comparison, the Moon Treaty's 15 ratifications doesn't hold a lot of weight, especially since none of them is spacefaring nations. Now let me tell you why this happened to the Moon Treaty. Its purpose was to provide rules to govern the exploitation of natural resources in space, including the moon and asteroids. Everybody wanted this. Most of what the treaty says reiterates the principles of the Outer Space Treaty. But the failure of the Moon Treaty to gain acceptance is attributed to only one provision, Article 11. It's famous for being the one provision that brought down the entire treaty. Article 11 declares the moon and its natural resources to be the common heritage of mankind, a special term of art, and calls for establishment of an international regulatory regime. Now, remember the Group of 77 for Module 1? Those developing countries pushed for a moratorium on the exploitation of the moon's resources, mostly because they weren't spacefaring themselves and they didn't want all the resources to be taken by the time they got there. But they were able to negotiate a compromise inserting the common heritage of mankind. The problem is that at that time, the phrase had been interpreted as giving collective ownership of the deep seabed in the law of the sea. This was a red flag. Countries like the US were afraid that common ownership would mean that profits would have to be split among everyone. And that was a non-starter for capitalist countries like the US. I personally don't believe Article 11 necessarily leads to that conclusion, but we can talk about that in the discussion forum. Also look at the PowerPoints I posted, which provide a little bit more background. Now a word about Assignment 2, which asks you to write an essay on the best arguments you can make to allow an asteroid miner to keep profits from resources mined on the moon. I'm interested in how well you can argue that compliance with the treaty doesn't necessarily mean your friend has to split any profits with anyone. Remember, all states, even the US, sent delegates to negotiate and approve the Moon Treaty before it was sent up for ratification. Good luck, and I'll take questions in the discussion forum, and thanks for watching.